The theory of the Kim's kids in the identified polling stations could not be taken as a yardstick of the performance of Kim's kids in the whole country. All affected voters who could have complained were not disenfranchised, as they were able to exercise their democratic right to vote manually. End of quotes. Based on the above holding by the Supreme Court, and considering that this court was being persuaded to repeat a similar exercise, I found it to be a waste of judicial time to embark on a scrutiny to find out an outcome that had already been ascertained by the apex court in the land. Although voting commenced at 12 midday, voters who were willing to vote were given an opportunity to do so. Time was indeed extended to compensate for the time lost. Samples of forms showing polling stations crossing past 11 p.m. and 12 midnight were attached to the second respondent, Max MR at 3. Nobody came forward to complain that he was denied an opportunity to vote. Indeed, no voter in Kibwe's West constituency was disenfranchised by virtue of the veil of technology. This position was affirmed by the Supreme Court itself in the said Raila versus RUTO case 2022 election petition. The petitioner alleged that the tallying process was characterized by irregularities such as inflation of results in polling stations, where more people voted than registered in the Kim's kits, hence lack of transparency in tabulation of results. He alleged that the first respondent did not adduce as evidence from the 7As to show how tabulation of results was done, and the results supposed to be signed by the agents were not signed. The gubernatorial elections held on 9th August 2022 in Makwiny County were constitutionally and validly held. C. That the third respondent herein, Mutula Kilonzo Jr., was validly elected and gazetted the governor of Makwiny County. 4. That the petitioner's repair cost of the petition assessed and payable at 1 million shillings to the first and second respondents jointly and in equal amounts, and 2 million shillings to the third respondent. E. A certificate of determination in accordance with Section 861 of the Elections Act to issue to the IBC and speak of the Senate. Those are the orders of the courts, and that's the end of the judgment. On that note, I come to the end of the reading of the judgments. Regulation 76 of the Election General Regulations 2012 provides the procedure of counting of votes. It provides as follows. 1. The presiding officer shall, in the presence of the candidates or agents, A. Open each ballot box and empty its content onto the counting table or another facility provided for the purpose, and shall cause to be counted the votes received by each candidate. B. Record the total number of votes cast in favor of each candidate. 2. Each ballot paper shall be counted as follows. A. The presiding officer shall, in respect to every ballot paper, announce the candidates in whose favor the vote was cast. B. Display to the candidates or agents the ballot paper sufficiently for them to ascertain the vote. And C. Put the ballot paper at the place on the accounting table or other facility provided for this purpose, set for the candidates in whose favor it was cast. 3. The presiding officer shall record the count of the votes in a tallying sheet in Form 3 set out in the schedule. 4. A candidate or an agent shall have a right, A. to dispute the inclusion in the count of a ballot paper, or B. object to the rejection of a ballot paper, whereupon the presiding officer may decide to uphold or reject the complaint and act as provided under Regulation 80. From the testimony of Adam 2, the constituency returning officer, after he received Form 7A from presiding officers at the constituency tallying center, he populated Form 7B in the presence of agents representing all candidates who signed the requisite form for declaration and transmission of results to the county returning officer, who also populated Form 7C and declared the winner as governor without any objection. That the petitioner was represented by one Kingola Muthusi, who signed the result declaration form as an agent. It was the petitioner's case or claim that he did not have an agent at the tallying center as stated. There is nothing on record to show that there were any anomalies or irregularities in the manner in which verification, tallying, and declaration of result was done. It is inconceivable for the petitioner to claim that voter verification was not properly done and the result inflated, yet he has no proof. None of the agents or voters came forward to claim the specific station or stations where such anomalies or malpractices occurred. This is a generalized allegation which lacks substantiation. On the aspect of 4 polling stations where votes cast exceeded registered voters, the same was explained and discarded, hence nobody gained out of it. Consequently, I do not find any ground upon which to find that there were glaring irregularities or malpractices in verification, tallying, and the declaration of results of such magnitude as to vitiate the results. Whether there were unexplainable discrepancies between the votes cast for the position of governor and the direct position. It is the petitioner's case that there were unexplained discrepancies in respect to the votes cast for the 6 elected positions. To illustrate the discrepancies, the petitioner indicated that the total votes cast for each position were presidency 290, 491, governor 281, 289, 538, senator 290, 550, and women rep 269, 465 votes. According to the petitioner, no explanation was given to justify the differences, yet each voter was given 6 paroles. In response, the first respondent, through the affidavit of Morris Keboy Raria, sworn on 20th September at paragraph 27, explained the reason why the said discrepancies were occurred. He stated that a result for count women rep in Kasheria Primary School, Kaseuni Nursery School, Kidhini Primary School, and Komboyo were disregarded as the votes cast exceeded the number of registered voters. No governor and women rep results were received from Kangaka Primary and Katurimbi Primary, as the same were misplaced, thus calling for police action. No votes were cast at Muvuti Primary for the position of senator, as the station did not receive Senate ballot papers, and lastly, there were spoiled and stray votes which were accounted for in the polling station diary. According to the analysis presented by both parties, the difference between the presidential votes and the governor was 1,001 in favor of the presidency, while that between the governor and the senator was 1,060 in favor of senator. There is no dispute that there were discrepancies in votes cast in the 4 aforesaid county elected positions. I have taken into account the total votes cast vis-a-vis the votes garnered by each candidate, as well as the difference in terms of votes cast for each position. The third respondent garnered 214,088 votes against the petitioner in second position with 63,252. Taking into account the explanation given to justify the said discrepancies, I am satisfied that discrepancies were not so deliberately created with any mischief in mind. The explanation given is convincing. In any event, the discrepancies in question are negligible as to vitiate any election result. It is tried that in any election exercise, minor infractions, omissions, and commissions are bound to occur. The discrepancies in question are not so glaring so as to call for nullification of election results. In the case of Raila versus RUTO presidential election petition of 2022 Supra, the Supreme Court at paragraph 285 restated its position in Raila 2017 presidential election petition at paragraph 373, where it was held that not every irregularity or procedural infraction is enough to invalidate an election, that the irregularities must be of such a profound nature as to affect the actual result or the integrity of an election for a court of law to nullify the same. Similar position was held in Wavinya and Ndeti versus IPC and 4 others 2013 KRR, where the court held that an election is a human endeavor and is not carried out by programmed machines. It went on to state that perfection is an inspiration, but allowance must be made for human error. Hence, what's paramount is that in the such errors, the ultimate will of the people is ascertained and upheld. This position was also held by the Supreme Court in Gadirao Peter Munya versus Dickson Mwenda Githinji and 2 others 2014 KRR, where it was stated that no election shall be declared to be void by reason of non-compliance with any written law relating to that election if it appears that the election was conducted in accordance with the principles laid down in the Constitution and in the written law, or that non-compliance did not affect the results of an election. Having taken into account the wide margin between the petitioner and the third respondent, the alleged errors, omissions, or irregularities leading to the discrepancies in terms of tally votes cast for each elected position do not, in my view, raise any red flag. Indeed, as stated in the case of Masi Kirito Mutegi versus Beatrice Nkadha Nyaga and 2 others 2013 KRR, not every non-compliance or every act of omission or breach of elections, regulations, or procedure can render an election invalid. In a nutshell, the petitioner has not established to the required standard how the vote discrepancies affected the validity of the election results, whether the third respondent was validly elected. Mr. Kimathi submitted on this issue on 2 aspects. Firstly, an election is not about numbers, but a process. In his view, the makwiny gubernatorial election exercise was tainted with irregularities that rendered the declared results invalid. Secondly, the delayed time of voting occasioned by various Kim skits rendered the whole exercise a sham, as over 91,000 voters were hindered from voting. On the other hand, the respondents maintained that the huge margin in numbers of the votes garnered by the...
Now we are ready to go and work. Now the case is behind us. We just want to forge forward and work for the benefit of the people of Makwiny. We wish to thank the council, Bobu, Chalo Bobu, Kevi, Kilonzo and team for doing a superb job. Asante.